Welcome back to part 2 of criminal liability. Again, as a reminder, click the link in the description below so you can get the full interactive experience with this video. Before we get into our topic, if you really are serious about your studies, I would urge you to join my school community. Simply click the website on screen if you're watching the interactive version. I have a criminal law study group with lots of free resources, and you'll meet others studying your topic as well. One major thing I want to announce is that I'm hosting a live for those about to start studying law or a new law subject, so you can see what to expect from the community. It will be in the first week of September, and more details will be on school. Okay, let's jump into our first topic. What do we mean when we talk about burden and standard of proof? We've all heard the phrase, innocent until proven guilty. And that's not just a saying, it's the foundation of criminal law. This means the burden of proof rests with the prosecution. They have to prove every element of the offense, and they must do so beyond reasonable doubt. Let me ask you though, in your own words, what does the term beyond reasonable doubt mean to you? Click in and write your answer, and I'll definitely give you my personal feedback on your response. As I said, the standard is beyond reasonable doubt. That's a high standard, and it's meant to be. This principle was firmly established in the case of Wilmington and the DPP in 1935. Lord Sankey called it the golden thread that runs through English criminal law. No matter how serious the charge, the prosecution must prove the defendant's guilt, not the other way around. To make this really clear to you, I'll send you an infographic study sheet on the burden and standard of proof. Just simply click to request and I will send the free A4 PDF to you. But notwithstanding this high standard of proof and the burden being on the prosecution, what happens when circumstantial evidence is so strong it seems overwhelming? Well, that's where things get interesting. Let's imagine a scenario. Imagine someone is found running from a crime scene, clutching a weapon covered in blood. There are no eyewitnesses, but the weapon matches the murder, and it is the victim's blood. In a case like this, the burden might shift. The court might say, "You were there, the evidence points to you. Can you explain why?" If you were representing the person running from the crime scene, what would your legal argument be on his behalf? Just type your answer in now. Just make it very short in note form. The question again is, if you were representing the person running from the crime scene, what would your legal argument be on his behalf? Just write that in the space. So again, the scenario is to imagine someone is found running from a crime scene, clutching a weapon covered in blood. There are no eyewitnesses, but the weapon matches the murder, and it is the victim's blood. In a case like this, the burden might shift. The court might say, "You were there, the evidence points to you. Can you explain why?" Well, here, when the court seeks the defendant's explanation, this is where we see the burden of proof being reversed, and the standard changes too. Instead of beyond reasonable doubt, the defendant now just has to prove his case, his position on the balance of probabilities. That's the civil standard of whether what they say, meaning their explanation, is more likely than it is not. So the defendant proving that he wasn't there, despite the overwhelming circumstantial evidence, he has to prove on balance. So it's more likely than not that he wasn't there. For example, if he said that he was simply walking along the street and someone ran up to him and asked him to hold this weapon, in his confusion, he did, and the next thing he knows, a bunch of police cars pulled up to him. The question then is that explanation more likely than not? That's what we mean when we talk about balance of probabilities. Okay, now let's turn to strict and absolute liability. Strict liability offenses are those where the prosecution doesn't need to prove mens rea, the guilty mind. It's enough to show that the defendant did the act, actus reus, even if they didn't mean to. You'll often find strict liability in public welfare situations, so areas like food safety, environmental protection, or health and safety at work. The idea is to encourage high standards where public welfare is at risk. But even in strict liability cases, some limited defenses might apply, like a reasonable mistake or if something truly unforeseeable happened. Now, absolute liability takes it a step further. In these cases, no defense is allowed. No matter how careful the person was, if the act happened, they're guilty. Absolute liability is rare and usually applies in regulatory offenses, sometimes called quasi-criminal cases. For example, not displaying a license correctly, even if it was an honest mistake. But here's where the line gets blurry. In English criminal law, the distinction between strict and absolute liability isn't always clear. A lot of what we call strict liability might actually be absolute in practice. I have prepared a PDF which sets out the contrast between strict and absolute liability, which I hope you will find helpful. And if you click to request it, I can get that to you to download at no cost. So what are the problems with strict liability? Well, one big concern is fairness. In the case of Callow and Tilstone, a case from 1900, a butcher asked a vet to inspect a carcass. The vet said it was fine, but it wasn't. The meat was unfit for sale, and the butcher was prosecuted. He'd done everything right, but because the offense was strict liability, he was still found guilty. So let me now ask you this. Do you think that was fair on the butcher or not? Take our poll on the Callow v. Tilstone case and let me know what you think. Now let's take the case of R and G 2008 with the 15-year-old boy and the 12-year-old girl he believed was his age. Even though he had no reason to doubt her, the law said he was guilty of a statutory offense. I will give you a moment to read the facts on screen. That's the harsh reality of strict liability. Given the strict liability of the statutory offense and given the age of G, do you think that the decision was just, or do you think it was too harsh? Please take the poll and write just or too harsh to let us know your thoughts. In any event, the thing with strict liability is that there are benefits too. In Housen and Woodward in 1972, a company caused pollution in a river they hadn't meant to, but the court held them responsible under strict liability. Why? Because protecting the environment is too important to take chances. I have created a mind map for Housen and Woodward, and if you'd like a downloadable copy, simply click to request it. Similarly, in the case of the Crown against Williams, a 2011 case, workplace safety laws meant that employers had to take extra care, even if they weren't directly negligent. Again, the goal was to raise standards across the board. Another benefit of strict liability, of course, is that strict liability can also save time in court, as there is no need to prove intent or knowledge, just the act. That means quicker justice and less expense. Still, there's a need for balance. I want you to again put your thinking caps on regarding this. What's your view on balancing speed against fairness in strict liability? Think about it and put your short answer in the poll. So in addressing this balance, courts usually start with the assumption that mens rea is required, especially in serious offenses. And unless Parliament clearly says otherwise, the presumption stands. You can get my PDF mind map on mens rea assumption by clicking now to request it. The fact is, we saw this presumption in Sweet and Parsley in 1970, where a woman rented out a property and her tenants used it for drug activity. She didn't know, but she was prosecuted. The law didn't mention mens rea, but the court said it should still apply. Why? Because the offense was serious and the presumption of mens rea is strong. So let's wrap up with some key cases that bring all of this to life. In the case of Pharmaceutical Society of Great Britain and Storquain Limited in 1986, a pharmacist filled out forged prescriptions. He had no idea they were fake, but the law under the Medicines Act didn't require mens rea. The court looked at the rest of the act and saw that other sections mentioned mens rea, but this one didn't. That omission was taken as deliberate, and so the conviction stood. Finally, in Nurse and Another and Republic of Trinidad and Tobago in 2019, the court considered everything. Was the offense serious? Did it impact public interest? Was there mens rea in other section of the act? Could it be unfair to convict without fault? The court concluded that unless Parliament clearly intends otherwise, mens rea must be present. In a nutshell, understanding these principles like burden of proof, standard of proof, and liability helps us see how the law protects not only society but also the rights of the individual. Thanks for watching, and I just want to remind you to visit the link for my school community for live chats and weekly drop-ins for criminal law as well as for other subjects.